DM Brayford versus Brayford. There's a motion filed by the plaintiff, Mr. Brayford, a ROPA motion regarding, in essence, Sebastian, as I understand it. My understanding of your motion, sir, is that your oldest child, Christopher, you say there is a DNA testing and stuff that was filed with Kent County. I don't have it in this file. It wasn't attached or anything to your motion, so I don't have it. And second, you say you need DNA on Sebastian. At this time, says I can check with Ottawa County for a removal. That doesn't mean anything, and I'm not going to check with Ottawa County. I'm trying to determine whether or not this is a divorce file from 23. We're trying to determine the paternity of a couple of kids. You got 1, 2, 3, 4, 5 kids. The two youngest, we're trying to determine whether or not you are the father of, correct?
Yes.
And it appears somewhere you say there's a DNA test. I don't know where that is. It's not in this divorce file. What?
It's from when I previously filed for divorce. I can try to get logged into the files.
Well, I can look that up. Okay, I can't go look up stuff in Ottawa County. Why don't you, ma'am, you understand the DNA test regarding Christopher apparently shows that Todd is not the father. Is that correct?
That is correct. And Joseph Rita must sign the affidavit of parentage for Christopher.
Okay, well, might be premature, but good that he did. I mean, it might be premature because I don't know that at this time. I don't know if the court has a finding. Did they have a finding in the last order?
Yes.
Okay.
No.
For Christopher, they did.
Just for Christopher. Was there a court finding that he was not part of the parent relationship, the marriage?
Yes.
All right, then we will do a similar thing in that I'm going to order a DNA test regarding Sebastian. Clearly, I'm sure it'll come back 99%, but I don't have it. And when we will order Sebastian and you and Mr. Brayford to have a DNA test. When that comes back, bring it back in front of the court.
We already have one.
One in progress?
Yes.
Is there one in progress then, ma'am?
Yes, there is.
Okay, is that through Ottawa or something?
It was originally for you.
Okay.
From the last divorce.
All right.
We had the final results for that.
All right. When you get the final results, just renotice this motion. If everybody can agree that those are the valid results and stuff like that, we will find that he is probably not going to be part of this. And then you can work on getting this divorce over with. Okay.
Yes.
All right. We'll make a note to check the prior divorce filing. Okay. I don't know what that case number is. When you get, so when you get the DNA for Sebastian, he will renotice this motion. You don't have to pay for the motion that way. You just renotice it and come on in. And if everybody agrees that that DNA is correct, I will probably issue an order that he's not part of the marriage. Okay. But you still got 3 kids you got to deal with in this. All right. You understand that, ma'am?
Yes.
Make sure you cooperate in the DNA testing. All right. And we'll see you back, I'm sure, in a month or so. All right. Thank you very much. Good luck. I'm going to start out by saying I've seen these parties, I don't know how many times already this year, and I'm not going to micromanage this relationship. The time's going to come from now on when people start filing motions. If you guys can't figure this stuff out, the loser is going to start paying some fines. This is seriously, I've seen this probably 3-4 times this year. I don't know if you know that, Mr. Lambert, or not, but
I am aware, Your Honor.
all right. Let me just start out and say this is Dad's, Mr. Stressman's motion for custody. There's a custody consent order from 3/28/22. It includes the first right of refusal and if other things that says the grandma or great grandma is to provide daycare. He's filed for a change of custody. Mr. Stressman, there is no proper cause or change of circumstance to change custody unless you can tell me something that isn't in your motion.
Yes, sir. As she's admitted in her statement against me for this. She's openly admitted that she's been giving my son to her aunt to be babysat.
Excuse me. I need him to speak up.
Okay, you gotta lean in there so that he can hear you.
In the defender.
He says that she admits that she gives the child to the aunt.
Yes, Your Honor. She's admitted it, in the.
Yeah, and so what do you want? It's not enough to change custody. And according to the response that I have, she attends school maybe 2 hours at a time in various.
Yeah, we don't know because she doesn't, I have proof that I asked her for clarification on her scheduling for work and.
I don't go get it. I don't go get that proof. That's not my job. That's your job. Okay. I mean, that's somebody else's job, not mine. The court doesn't do investigation. I got 25 cases today, and if I have to do investigation on 25 cases, I'll never go anywhere. You can provide the proof. Mr. Lambert has filed a response saying she goes a couple hours here and there. The problem with, and I don't even sign most judgments that include a first right of refusal because they are just exactly like this. How long is she gone before she should be telling you? 10 minutes, 15 minutes, a half hour, 3 hours? What is the amount of time? It doesn't say in there.
Openly states that if anybody is to drop off or need babysitting, they're supposed to consult with the other party first before they do give it.
I understand. That's what I'm saying. If she suddenly has to go get a prescription at the at Walmart and says, I'm going to go because they called and said it's available. I need mine, whoever's available to watch. She's not going to contact you for that.
Well, I mean, if you're gone for hours, a period of a time during the day.
If you're gone for hours, and maybe the best thing to do is to deny the motion for change of custody and to put in a reasonable amount of time that either party is gone. Mr. Lambert put in his response that you go work out at the gym with somebody else. And
there's no proof of that.
Well,
I have proof that she's doing it. She openly admits to it.
I understand. I understand. I'm not going to interfere with her education in any way, shape, or form. All right. I'm more interested in putting in a time frame that the first right of refusal would kick in. Now, quite frankly, this isn't even a motion about that. Your information is that she's violated that, so you want me to change custody. And that is not enough to meet what is called vidvarka, which is proper cause or change of circumstance. Just isn't enough to change custody and to even have a custody hearing. It may be a violation of the court order, which you can do in order to show cause, or you can request from the friend of the court, but I don't think they will do it based on this. You can do an order to show cause as to why she shouldn't be held in contempt for violating the court order, but that's the most you can do.
Is there a way for us to at least get a schedule of when she's not with him? And I mean, that's the whole point I thought first refusal is that if she's not going to be with the child, because she already gives me back before her parenting time. She doesn't even take him for her parenting time. She turns them into me earlier. I have all the documentation of her not actually even taking her full time. That's what she's been taking me to court here every month I've been here was for more parenting time. And she doesn't even use her full parenting time. And then she's going out.
But you want more parenting time. So she leaves him with you. You win.
I want my son. She doesn't want him.
That's an
No,
accurate.
when the child support case, that's when she started fighting for more time for her son because she doesn't want to pay child support.
Your Honor, none of this is before the court. My client definitely denies it. This is very simple. This is a matter of control, which is why we're here all the time, because Mr. Stressman has a control problem. I am willing to do this, Your Honor. I'm willing to do this. If he wants the right of first refusal, perhaps we should define it. I would argue that in order to avoid control issues about exactly how much time you were gone, how long you were gone, I would say if they're unable to exercise one of their parenting times, maybe a day or 6 hours because of a work schedule, but anything less than that is a matter of micromanaging and control, and we need to move beyond that. When Mr. Stressman has his personal life, and my client has hers, my client should not be in his personal life, and he certainly should not be in hers, and we certainly should not be in court every other week, every other month for these type of issues.
My thought is, and I was trying to get to it, is that I would like to see put in the first right of refusal if it's going to be for more than 4 hours.
So be it.
It states in the refusal or in the first refusal that my grandmother and mother are to be the first ones to be contacted for daycare and babysit. So why is that not being done?
I'm just telling you, because this first right of refusal, I think we should modify it. So if she's going to be gone for more than 4 hours at any given time.
Lie about that as well, like she's been doing, because she's telling me that she's not.
All right. So what do you want me to, ma'am, you got to tell the truth. What do you haven't presented anything. I understand, and I'm not fighting you about
And
that.
then for control, I filed 2 motions. She's filed 6 or 7 of them since we.
I've just told everybody at the beginning that I'm tired of this. Okay, I'm tired of seeing this every time, and I'm gonna start putting some constraints on losers, not right
So
now.
what would I have to bring in here in order to prove for a full custody switch? Well, what would you?
I can't advise you. I can't advise her. I can't tell you what you gotta do,
So I was gonna
okay?
get a lawyer that I won't afford.
That is the absolute best thing you could
She
do.
can't pay for child support. She can pay for a lawyer.
Well,
7 days.
I
12 months.
don't go there, all right?
Okay.
Don't go there. I'm gonna deny your motion for a change of custody. I don't think you meet Vidvarka. It's not really in front of me to put a time on first right of refusal. I would put a 4-hour time on it if both parties agree. Otherwise, we'll just come back at some point when somebody wants to file a motion regarding that.
Your Honor, my son is coming to me and telling me these things like he's.
I'm just asking, if you don't agree with it, I'm not gonna force it. I'm just gonna deny the motion for custody, because that's the only thing that's in front of me. You filed a motion for change of custody, and that's what it is. That's what it's based on. And I do not find that meets Vidvarka, which means a proper cause or change of circumstance. I don't think it raises to the level for a change of custody. Go to an attorney. Maybe you can fashion something around it, but I can't tell you what it would be.
So if anything goes against the order that we have, that doesn't.
That's an order to show cause.
So
if you violate the court order,
for school and work.
Listen, if she violates an order, it's an order to show cause why she shouldn't be held in contempt, okay? And there are significant rules that you have to file to do that, to even get it in front of the court, all right? That's what it is.
Right.
If they are sufficient enough that there's proper cause of change of circumstance, I can find it, but I'm not finding that at this time, okay? So in effect, I am denying the order for change of custody, and we'll leave it out there because nobody's going to agree to the 4-hour thing for first right of refusal. And that's not really in front of me, as you know, Mr. Lambert.
Excellent. I'll prepare the order and submit it under the 7-day rule, Your Honor.
Thank you very much. Thank you, sir.
Thank you.
Go ahead, attorney.
I will.
DM, it's Bagley versus Bagley. Both parties are present via Zoom. The plaintiff, her name now is Baraga, has Mr. Lambert here representing her. This is a motion by the mother regarding custody, parenting time, and child support. I'm gonna kind of boil this down. It's basically the parties had 50-50 in a judgment. Looks like on 1/27/20. They had equal time, and now since then, apparently Mr. Bagley, and it states in there that was the time that they had was based primarily on his work schedule. Apparently his work schedule has changed many times since then. I don't know what the parties are doing regarding 50-50. The only thing that Ms. Baraga has to follow is the 50-50 based on the time that's in there, which is week 1, Monday through Wednesday, and Friday to Monday, and week 2, he gets Wednesday to Friday. That gives him his 7 overnights. You don't have to accommodate other various schedules. Dad admits he's done a lot of job changing and all this kind of stuff. And he admits he hasn't been the best person in the past talking to the mother. Mr. Lambert, I think I kind of summarized your request that things just keep changing. What do you want to add to that?
Yes. I find it interesting. The parties seem to be in agreement on a number of the allegations set forth in my motion. Schedule changes, as you indicated, or job changes, as well as shift changes. Sometimes having to work as early as 4:30 in the morning, which means obviously he's leaving earlier than that to go. Paragraph 8, my client alleges that he is exercising now approximately 2 overnights a week and has been doing that for the last 4 months, and he admits that. So there's the problem right there. We are no longer doing 50-50. My client is doing the majority of the parenting time simply because his work schedule keeps changing and his jobs change. In addition, there's some issues. There's some issues that border on abuse, inappropriate parenting, name calling of the mother, inappropriate example for the child. And it's nice that he admits he's going to church to try to become a better person and counseling. Although my client indicates he's not in a counseling regular enough, and it's not really working that well, and she'd like him to have more professional help in that regard. She's concerned that some of this anger outbursts, profane name calling, at times being a little physically aggressive, has spilled over and impacts the child. These things happen in front of the child also. She's concerned that his priorities just aren't in place with regard to caring for the child, thinking about letting the male neighbor watch the child alone.
But
that fell
it
through.
didn't happen as I understand it.
Right, simply because my client said, "Oh, no way in Hades."
And I understand, and that's what they're supposed to do. That's how they're supposed
Exactly.
to go on and say,
Exactly.
he says no, and he says, oh, okay.
All right, so we're fine with that, but we need the relief requested here, Your Honor. We need to modify the parenting time. My client should get physical parenting time, physical custody. Parenting time needs to be changed to reflect the reality here, what he's doing. We have proposed in B of our relief a schedule that would accommodate his current parenting time. We're thinking about Wednesday and Thursday overnights. We're also thinking on the off weeks, every other week, Wednesday and Thursday. On the off weeks, a Thursday overnight. That accommodates his current schedule. We'll see how long that lasts. He indicates he's looking for another job in his response, so we don't know. A referral to front of the court, we think would be appropriate. We need a mutual order along the lines of E in my request to stop disparagement, alienation, embarrassment, threatening, name calling, profanity, etc. We need.
I don't have a problem with it. That can even be mutual because I don't care.
Yeah, no problem with that being mutual. We need something about the babysitter. We don't want to revisit this again and find out that
I'm going to say that was a non-issue because he thought of doing that. She said no, and it ended. That's the way these parties are supposed to work on joint legal. Is if he had gone ahead with it, that'd be a different thing. But
there is still an issue there, and the issue is that he will require babysitters in the future. And all we're doing is saying we want babysitters that the child is comfortable with, and that the mother knows who the babysitter is, and we're willing to do it mutual also. We're happy that this last issue resolved itself, but there's still an issue here in the future. My client cannot accommodate his third shifts all the time.
I understand. I'm not going to require her. I mean, if the child, sir, I don't mean to interrupt you, Mr. Lambert. I got a lot of emotions, and
I understand.
Exactly. The bottom line is, what is your work schedule now?
Okay. Good morning, sir. Your Honor. My work schedule currently is a third shift work schedule, where I work from 10 p.m. to 6:30 a.m. And my 2 days off currently are Tuesday and Wednesdays.
So obviously you can't have 50-50 with your child.
I understand that. And so right now, and this is kind of what I alluded to in my response, sir, is I believe that entering into this third shift commitment has put an undue burden onto myself, Isabella, and the child.
It is what it is. They all have to work. You got a third shift job and you can't have her like you could before.
However, the plaintiff did tell me before I started this that we could work it out and we could figure it out. My plan was just to work here because it's a union shop and everything's based on seniority, sir, to possibly get first shift, which I do want to point out or bring to light new information where we're bidding on jobs, and on the 7th.
Good. I hope I win the lottery and don't have to do this anymore. So I mean, I don't know what the future is. All right, that's not what I'm looking at right now.
Okay.
You don't know what it's going to be, and as I say, if I win the lottery tonight, this is the last you'll ever see me. But I doubt I will, and I don't know what you're going to end up with. The bottom line is at this point that the 50-50 custody doesn't work because your job. I mean, you'd have to have somebody that doesn't seem to make sense that she would be accommodating your schedule all the time.
You're right. Correct.
And so I think there is marginally enough to review custody. I'm not going to change any custody here today. What I really think I'm going to do is as requested, I think maybe I should refer this to the friend of the court for a custody, parenting time, child support review, so that they can get to the bottom of what's going to happen. If you get something changed within the next, a couple of weeks, when you have your friend of the court meeting, you'll be able to tell them that. All right.
Yeah, that'd be great.
So Mr. Lambert, I do find that there is proper cause of change of circumstance to look at custody. That's not a finding. I don't know how to say it. It's not a evidentiary finding that if we end up in court, I've already found it. You'll have to show it if we end up in an evidentiary hearing. I'm going to try and avoid that because these parties actually kind of get along. There's been a lot of accommodations. Mr. Bagley, I'm going to tell you, you admitted to some text messages and stuff. If I get anything from you that is anything other than respectful of Ms. Baraga, all right, Mr. Lambert is going to file a motion, and I'm going to, I don't know what I'm trying to say what I can say on the record. It's not going to go good for you at all. I don't care whether you're going to counseling or whatever. That is going to stop as of today. All right. You will not disparage her. You will not talk. You will not swear at her. You will just have a relationship that I assume you don't want her treating you the way you treat her. And
Correct.
So you will abide by that throughout this case and from now on. So that, Mr. Lambert, you can put in a, whatever you want to say, disparaging against both parties. We'll make it mutual. I'm not going to order him to do anger management or parenting classes. If he doesn't and things go bad because of it, he's going to be the one to pay for it. I mean, it's obviously the child's going to spend less time with him. You asked for a first right of refusal. You heard me in the last case. I'm certainly going to grant that.
No. I understand, Your Honor. I understand. Everyone thinks that's what courts like.
Everyone think that's a great thing, and it's one of the worst things in a judgment. So,
all right. So, what about a change in the temporary schedule at this time pending the review? Right now, I thought he had Wednesday and Thursday off. Now it's Tuesday and Wednesday. So we have no problem with him having those overnights, Tuesday and Wednesday, and every other week, and Wednesday on the off weeks. We have no problem with the overnight.
He has 50-50 right now. So why can't he have it every Tuesday and Wednesday overnight when he's not working? Ma'am, I mean, basically, he's not working. Right now, he has 50-50. All right. So when he is not working on those nights of Tuesday and Wednesday, he can get the child what time on Tuesday and return the child Thursday. She goes to school, I'm sure. So he can get the child Tuesday after school until Thursday at 6 o'clock. All right.
6 o'clock or return or just drop the child off at school in the morning.
Well, on Thursday morning. Well, what time do you go to work then, sir?
10 o'clock p.m. I start my shift.
Oh, he can see her till 6 o'clock, get her from school, have dinner, then take her back there at a reasonable time. All right.
I'm sorry. Could you state that time again? On Tuesday after school?
Tuesday after school until Thursday at 6 o'clock.
In the morning or evening?
Evening. He'll be responsible for the transportation from the school and everything like that.
Yeah.
Thank you, Your Honor. I'll prepare the order.
We'll just do that. Make sure it's listed as a temporary order.
All right.
We'll also end up reviewing child support and stuff like that, but let's get to the bottom of this. Both of you, well, I don't have to tell you, Ms. Baraga, because your attorney will, but make sure when you get the information, make sure the friend of the court knows your correct address, sir. All right, because they're going to send out stuff to you and you better cooperate. Otherwise, I'll just get the friend of the court's view of it. Mr.
And we're splitting costs and you're doing the order of referral, sir?
Yes, 150 from each of them.
All right.
All right, that's for the custody parenting time evaluation. Each of you will be responsible for it. Make sure you pay it or else, again, it's going to come to me and you're not going to be in good favor.
Okay.
All right, I'll prepare the orders.
All right, thank you, everyone.
Thank you. Goodbye.
Thank you.
All right, can you hear me, ma'am?
Yes.
Okay, Mr. Inskeep is here in the courtroom. All right. This is the matter of 22-1841 DM Inskeep versus Inskeep. Ms. Inskeep is present on Zoom. Mr. Inskeep is present in the courtroom. She has asked in her motion that she just wants to start child support since the Mr. Inskeep has been released from Kent County Jail on 3/15. There is no child support order at that partly because it looks like back in 22, there was a judgment of divorce and they had 50-50 and there was no child support ordered. Obviously, he hasn't been able to exercise 50-50 while he's in jail. I don't know how long he was there for, but we need to have a review. What kind of time does he, what kind of time do you spend with the kids now?
Whatever she lets to. That's when I have. And it's, when they're at school, it's hard to see them at school. And then they got after school programming too. So by that time, she's, at work to get them. She won't let me have them overnights or anything, this is where I'm saying.
Ma'am, can you hear him?
Yes, I can.
All right. Well, it's appropriate to send this to the friend of the court for them to determine what is appropriate child support. It'll commence on the day when you filed the motion, but sooner or later, it is what it is right now. All right. Obviously.
And now that I'm back to work, like my first paycheck was this week, and I already gave him mine.
And he did give you some money from his new employment, ma'am?
He did send me money, yes.
All right. Well, what I'm saying is whatever money he does give to you, whatever child support they say he's supposed to pay. All right. I want you to make sure that you give him credit for the amounts that he does pay to you. All right. And I'm going to tell him that when he pays you the money, he should make you sign something to receive it, because I've seen this in the past that it doesn't get credited. And the fact, he could just sit here and not pay you until the time comes when a friend of the court says a certain amount of money, then he's in arrears, then he starts paying. But if he's going to be there to pay you, I want you to make sure that he gets full credit for it. All right. So he'll be expected that when he gives you money, you're just going to sign a receipt for it and say on April 27, I received $300 from him in child support. All right. Otherwise, he's probably not going to pay you, or I would tell you he should.
Right.
All right. We'll refer it to the friend of the court. They'll be in touch with all of you, both of you. There is no fee for that. So they'll be in touch with you and make sure that you cooperate with them. All right. All right. Thank you. We're adjourned. Thank you, sir. Muller versus Muller. Both parties are present with the respective attorneys. Ms. Bueno for Mr. Muller and Ms. Watts stay for Ms. Muller. Ms. Watts stay. You are one of the most unlucky people I know. I don't know what your husband looks like after you hit him with that hand, but it had to hurt. All right.
Yes, it definitely did.
Yeah. See, you have a significant, I think, broken wrist is what I'd heard in the past that was doing, that was there. So sorry to hear that.
No, it was a good thing that we had adjourned that other matter that we had, because I broke it that weekend before that hearing that was supposed to happen on Monday. So
yes. So you're saying
the fact that we had to move that worked out well, because otherwise I probably that morning would have been
but thank you.
Crying to the court.
I'm sure. And I would have probably bought it. All right. Well, I hope you heal rapidly.
Well, thank you.
All right. This is a motion filed by the defendant to enforce the judgment of divorce. I just got a response from Ms. Watts stay. All of that's well and good. But the bottom line is the judgment says about 72,000, I think now, was to be made by 11/22/23. I know they're significant. Ms. Muller says, gee, I'm taking care of our daughter at college and this and that, but it's not considered in there, and I can't modify a judgment of divorce at this point. I also understand Ms. Bueno that he has approximately $8,000 left to pay on the tax judgment. Is that correct?
He currently has 8,100 left to pay on that.
Well, all right, then that's probably going to make sure that no attorney's fees are now brought, since he's not coming exactly with clean hands. Why hasn't he paid it?
Answer.
You can go ahead and answer.
I've been making monthly payments, Your Honor, of $100 per month. My income is not that high, and I can't afford much more than that per month.
That'll be 81 months. That's, geez, oh, Pete's.
Well, Your Honor,
No, the bottom line is she owes the money. And you don't have any problem, I assume, subtracting that out of the money she owes.
None.
So the amount of 72,815 would be reduced by the amount of money that is owed to him, and whatever that is, 64,000 is what you're seeking a judgment for.
Yes, we could do that.
Ms. Watts Day, I don't think I have any place to go with this other than to order the payment that's due. I know that the parties came in before and they wanted payment because she'd had money from sale of a house or something. And I, of course, did not move up the judgment time because I wasn't going to modify a judgment of divorce. I'm still not going to modify it. I don't know what you want to say, but
I understand, Your Honor. I mean, I recognize, and my client is not disputing that the money is owed. The issue is she does not have the ability to make it in a lump sum payment. And, you know, if the court gives a money judgment or a judgment to make the payment, she's going to do everything within her power to make the payment. But the proceeds from the sale of the home, I had asked her about that this morning, and she can confirm on the record here today, but she responded that I mean, they had incredibly significant tax liability. About 100,000 went towards that. She had to pay attorney fees from the underlying divorce case. So she really didn't have any money left from the proceeds of the sale of the marital home. So, I mean, we're in a situation, we're not disputing that the judgment and the MSA in particular, you know, requires that these funds be paid. It's just a matter of how can we get him paid? You know, and I did reach out to Ms. Bueno yesterday. Obviously, I'm just coming in on this case, so I'm still trying to get up to speed completely. You know, we're certainly willing to work together on, or work with them on, you know, some sort of payment plan. But I understand the court, you know, has limited ability to, you know, to modify a judgment.
I would love to have the parties work together on it, but quite frankly, other than that, I got to order basically immediate payment because she's 6 months past due on it. She signed the MSA as well as the judgment of divorce. It is what it is, and I'm not, like I say, I didn't modify it before, and I'm not going to modify it now, other than to say that we should take into account the 8,000 that he owes. There's no reason for her to pay him and him to pay her at $100 a month. Okay. So I'm not gonna, that would be ridiculous. So that should be done. Ms. Bueno, I assume you will talk at least to Ms. Watts Day to see if there's anything that can be done, keeping in mind that she still has one good hand and can probably use that against whoever's there. She's obviously tough. She's tough. So
well, I mean, yeah, I will definitely talk with opposing counsel, but I mean, as you already said, we're 6 months past the due date on top of 2 years of giving her time to do it. So we're just looking for the lump sum. Something else that I think might be helpful is also the availability to do some discovery, just to kind of see what is out there and available. We understand that the plaintiff is on numerous boards and receives income from that as well. And that would be another avenue where we may be able to get this paid off.
all right, so all I'm asking you now is, do you want a money judgment for the amount that's whatever it is? I think it's 72,815 minus 8,100.
Yes.
And basically, I'm not going to order attorney's fees, even though I was going to at the beginning, but I don't like the fact that he owes money and is paying it at an incredibly slow pace, and she owes money and paying it maybe even a slower pace. But we got to do something. If that's what you want, I'll give you that. I also think that at some point, once the money was due, we should start charging judgment interest. But I guess because both of them owe money and both of them, I would start the judgment interest like, where are we here? May 1, because they both owe money on it.
Your Honor, would you reconsider the attorney's fees? And the reason for that is because of the party's income is so different. That's why we had the payment schedule for the plaintiff to make a specific dates, because she has a lot more funds available to her, whereas my client does not. There is no deadline for him to pay on the taxes, and he has been making a good faith effort with $100 a month. While it hasn't paid everything off, it's still a good faith effort based on his income.
No, at this point, partly because also, partly because nobody put anything in there about him making payments on a judgment part that he owed. Maybe if you'd come forth and said, you know, we want to subtract this out and all that kind of stuff, but I came here with the idea that she owed 72,815 and I was going to just get it, with a money judgment. Once he gets paid, he has enough money to pay attorney's fees. And as I say, I had down here, I was gonna give you that, but when I found out that he still owes money, and a good faith effort, like I say, $100 a month would take 81 months. I don't know. That's getting up into pretty high division for me. But I think it's over 6 years. So I find that was a little bit deceptive, not indicating that he would get rid of that 7,200 and lower it. We got to get this figured out. You can have a money judgment. You can garnish your wages. You can do anything you want. I'm going to ask you to negotiate some with Miss Watts Day. And ma'am, you know, I don't really care what your problems are afterwards. I can't care about them. They are what they are. The judgment is the judgment. What you owe is what you owe. You say you got a child in college and stuff like that, and you're paying for it probably because he can't. Doesn't matter. You owe him the money and you've owed it to him for 6 months already. And I don't find you had much of a good faith effort to pay him because you aren't even paying him $100 a month. And that's, don't answer. All right. I'm suggesting that you don't. It is what it is. I'll give you a money judgment interest to start the 1st of, oh, wait a minute. We're the 1st of April, aren't we?
Yeah.
1st of April. It can start. I would hope that the two of you, you're going to be drafting the order, Miss Bueno, but before you send it in, at least talk to Miss Watts Day, because if you guys can come up with something, send in a stipulated order on what you guys agreed to. All right.
Okay. Can we also do some discovery so that way we have more information to be able to enforce that money judgment?
Yes. What kind of time do you want? 45 days?
Yeah, that would be good.
Miss Watts Day, any problem with that?
No, Your Honor.
I would think now that Miss Watts stays on it, you can make requests of her also to get the appropriate documents and not spend a whole lot to do that. Miss Watts stay, I'm sure you will provide whatever is appropriate. Work together. All right. But I'll give you 45 days for discovery too.
Okay. Thank you.
Thank you all very much. Take care. Have a good day.
Thank you, Your Honor.
Watts Day. I hope next time I see you, God only knows what'll be there on that.
I know. I'm not sure what it'll be next time, but hopefully better.
Yes.
So, thank
Take
you.
care.
I appreciate it. I assume you're very excited about your Wolverines advancing to the Final Four.
Yes, I am. That's better than advancing in basketball in my book.
Yeah, I figured. I figured you were very happy. I myself was a little sad, but
I watched that game. I watched that game and it was wonderful. I'm sure I enjoyed it a lot more than you.
Yes, you did, but that's okay. So anyways, okay, good luck to your team. Bye.
It's resounding quiet, so I'm assuming no. Miss Delgado, can you hear me? Well, we're off to a great start.
Yes.
All right. We're waiting. Miss Delgado was on here just a second ago, but she wasn't connecting, so she's coming back. Let's see. Miss Delgado, can you hear me? Mr. Sanchez, could you remove your hat, please?
Oh, yep.
Thank you. Ma'am, can you hear me?
Yes, I can hear you now.
All right, we're here in 30 DP, matter of Delgado versus Sanchez. Both parties are present by Zoom as well as prosecutor, Ms. Michelle Smith Lowe. This is a request for entry of an order of a judgment of paternity in a uniform child support order. I do have the results of a paternity test showing 99.9, a lot of nines afterwards, percent, that Mr. Sanchez is the father of Zion. Mr. Sanchez, do you have anything to say about that? I'm going to enter the order that you are now the legal father. Do you agree?
I agree.
All right, we'll enter that. Then the next order of business is the number of what should be paid in child support. I know that the prosecutor has gone through A number of things to determine. There's actual income for both parties that have been determined. At this point, at least, there are 0 overnights, probably because he just became father. And everything in here appears to be correct. Both parties have additional children that they were given credit for, and the amount of $217 a month does appear to be correct. Ms. Smith-Lowe, is there anything you would like to add?
Your Honor, I would like to place on the record that as the court knows all of the filings, the case was filed September 20th, 2023. Service was proper. Mr. Sanchez answered and asked for genetic testing, and a pre-hearing conference was scheduled with the parties and held with both parties separately on January 25th. The calculation was based upon their actual income that was indicated to me, but at the time, it was based upon Miss Delgado having 365 overnights. Recent correspondence with Mr. Sanchez has indicated that there, like as recently as this week, that he has overnights and they split childcare. But we didn't include childcare because they didn't want it included because they both pay equally and have consistently paid every other week. But if there is an issue with overnights, that should be included.
All right, thank you. Approximately how many overnights? What is the schedule? Are you, Ms. Delgado, what is the schedule of Mr. Sanchez being able to see Zion?
We have agreed to do 7 days and 7 nights, so a week each.
Oh, so you're doing like a week on, week off type thing?
Yes, so he'll get him Wednesday night, and I'll get him back the following Wednesday night.
All right. Then Ms. Smith, if you could actually calculate that, it's probably going to be about 0 is what it's going to come down to. But
I will, Your Honor, with all things remaining equal, base support would be $73.
$73?
$73 a month.
A month?
Yes.
Look at, are you guys splitting daycare and stuff like that?
Yes, but I actually currently got released from my job, so it's going to get harder for me to pay it myself. I do have a partner that's assisting me at the time, but that just currently happened, and I haven't been able to communicate it to the prosecutor.
All right, well, part of it, see, once you're released, you're responsible to get a new job, okay? I don't know what your thoughts are.
Right.
And if nothing else, you would probably be imputed at about $16 an hour as if you're earning it. I mean, I know there are jobs out there and things that you can do, and you're splitting things. I'm just wondering if it's, if the new amount is appropriate, if the two of you are just basically taking care of equally splitting stuff and all that.
I mean, as far as splitting stuff, I'm not sure if it's split in half because I have taken care of Zion for most of the part at this point. As far as he's been in the picture, he's taking care of him on his side when he's with him, so I don't give him anything of my stuff. And I have my stuff, and whatever he gives me from his home goes back to him. So I believe we're splitting half and half of care.
I guess what I'm asking is, should we deviate and just let the two of you say that you're not going, I mean, other than the medical, I think we have to do the medical amount because you're probably medicated. Is that the appropriate amount that we should use now, is the ordinary medical, because you guys are taking care of everything? And I don't know that it would be an appropriate deviation if you're each sharing 50-50 and sharing appropriate daycare and costs and all that kind of stuff. Then you need to split the costs. Is that?
Yeah, I think, yeah. Yes.
Mr. Sanchez, I assume you agree with that also.
I agree.
All right, that means that you're going to be sharing equally. I mean, if there's medical expenses and stuff like that, you got to share them. The order, I think, Ms. Smith-Lowe, at this point with the deviation, would be the $17 for the medical, because I think, isn't that Medicaid?
Oh, Your Honor, actually, with the new calculation of 182.5 overnights, ordinary medical would be $21.
All right.
But Mr. Sanchez's income is higher than Ms. Delgado's. So does the court believe that the $73 is appropriate?
I think based on their statement and based on the agreements that they've made, that the parties, we can make it at zero, that each party is responsible for half of everybody's expense, with the exception of Mr. Delgado will be responsible for $22 a month in ordinary medical.
And the birth costs?
That's, you tell me what you want on that.
And the birth costs would be, yes, his share of the birth would be 61.
His share of the birth cost would be $61.
I'm sorry, $2,361, and then the additional $66 for the genetic test.
Well, I can't do anything with that. That's just that in there and I, sir, you'll be paying monthly on the birth costs and stuff like that. The prosecutor, they'll set up a payment schedule for you. That's just your part because you're paying half of everything that includes half of the birth costs. All right. You understand?
Yes, sir.
So does Miss Delgado understand that there would be no base support, but he would only be, the court you're saying should only pay the $21 in ordinary medical?
Yes.
Yes.
And that's all right with you. If something changes significantly, you can ask for a child support review. All right.
Okay.
At this point, I think we'll deviate to I mean, I know it's not her partner's responsibility also, but these parties appear to be working well because they've agreed already on 50-50 before we even got here, and everybody's paying the expenses. So let's do a deviation to 0 for base support, 22, and then include whatever you have to in there for his birth costs. All right.
Thank you, Your Honor.
All right. Thank you very much. Thank you for working together, Ms. Delgado and Mr. Sanchez. I hope you continue to do that. The child will come out a lot better and a lot happier child if you continue to work together on this. Okay. Thank you.
I appreciate it.
Mr. Sanchez, anything else? You're going to be responsible for half. So, I mean, when your child starts, playing baseball, you're each going to be responsible for the fees and stuff like that. Do you understand that? I don't know if he's connected. Yes.
Looks like he's frozen.
Yes,
All right. Good luck, everyone. Work together. Thank you. We're adjourned.
This is Abigail Davis.
Ms. Davis, can you hear me? Oh, you got to pull over.
Yes, I can hear you.
You have to pull over. I can't have you on Zoom while you're driving.
Okay, sounds good.
This won't take too long, so just find any place to pull over for a minute.
Yep, I will.
Say Davis versus Samuels. Miss Davis is pulling over. She is on Zoom. Mr. Samuels apparently has not logged in. There's nobody out there you think that's him?
Not that I would think so.
All right.
Vet cells are in waterways. So
Yeah, all right. We also have a representative from the prosecutor's office, Ms. Michelle Smith Lowe. We're here on a judgment of paternity, as well as a UCSO. The father, who is not present via Zoom, does not dispute paternity, so we can certainly enter an order of paternity for this child, who I think is Lewis. I think the child's Lewis and is 4 years old.
Yeah.
Okay.
5. He's 5.
5. Well, that was close.
You were close.
And the parties apparently have 2 other children that are being handled in Ottawa County as far as the orders there. And it looks like the prosecutors worked with the parties to set an amount that works for everybody, not necessarily exactly as in the guidelines, but I think it ends up with $369 a month for this child. Is that correct, Ms. Smith Lowe? Because it's all part of a greater amount for 3 kids, right?
Yes, $356, Your Honor, for this child, so that the Ottawa County order for 2 children can stay in place.
Okay.
And not be disturbed. As the court is aware, we were in front of you, Your Honor, in February, I believe it was, February 9th. And at that time,
There's a gas station there. Sorry.
on February 9th, both parties joined. At the time, Mr. Samuels wasn't working, and the court indicated rather than change the effective date, he adjourned and renoticed to today.
All right. All right. So we will enter the orders that have been proposed here, making him the father, the legal father of Lewis, and entering the child support order in Kent County that coincides with Ottawa County, so that the total amount is agreed to. Do you agree with that, ma'am?
Yes.
All right. He's not on.
Right. He probably forgot, to be honest.
Right, but you haven't pulled over yet.
No, I'm working on it. Sorry. I'm getting in the gas station, you know.
Well, Ms. Smith-Lowe, you can submit the orders to me. Unless there's something you want to say. If there's something you want to say, Ms. Davis, then I gotta have you stop.
No, I'm stopped now. But I just wanted to mention that he still doesn't have a job, but I mean, I think we should just go ahead with it at this point. It's been long enough.
Yeah, he's got to find a job, or else we're going to impute him income basically to what he had before. He's got to work. There are a lot of jobs out there today, even if you have to work a couple of them at McDonald's and Wendy's or something like that. He's got to, because he has to support his children.
Your Honor, I just want to also place on the record, and I'm sure I did before, that the original calculation for 3 children was about $1,546, but the parties agreed to an additional deviation of $969 for 3 children, and then the Ottawa order would to make this lower than it would have been.
So basically, he's getting a break as it is, and Miss Davis apparently has allowed for all of that.
Yes.
Correct, ma'am? Is there anything you want to add?
No, I don't think so.
All right. He's got to get a job. We're going to enter the order of paternity as well as this child support order. Thank you all very much. I appreciate it.
Thank you, Your Honor.
Yes, it's the matter of Granison versus Holt. Mr. Granison is present here in the courtroom. Ms. Holt is not. I asked Mr. Granison prior to us going on the record in this case, if he had given.
I'm sorry. I'm Miss Granison.
Oh, I got it backwards. Sorry. Yes, I do. All right. Mr. Holt has told me just before we went on the record that he in fact served the mother first class meal. He said last Tuesday or Wednesday or so. You have something here that says you served or you mailed it to her on the 20th of March. That would have been 2 weeks ago.
That's when I received the paperwork.
I just need to know when you sent it to her.
So was last week Tuesday? It was last. I'm not.
It makes a huge difference. All right.
Yes, sir. It was last Tuesday.
Last week before Wednesday.
Yes, sir.
And how did you send it to her?
Mail.
Mail.
Mailbox.
And that was to her last known address in Saginaw, apparently. All right. Well, did it come back to you or anything? Did you put a return address on it so it could have come back or what? You have any contact with her?
Like very little. It's like I'll talk to her and then the next time like her number will change.
Well, I'm gonna deal with it based upon see what the problem is when you say you signed it saying you mailed it to her on the 20th, and then you come in and you tell me you didn't. I understand, but this is when we got to depend on proof of service. Somebody has to tell the course, yes, I put it in the mail on that day. Now, why don't you raise your right hand? Do you solemnly swear from testimony given in this case be the truth, whole truth, and nothing but the truth?
Yes, sir.
All right. You just told me you served her by first class mail at least before last Wednesday.
Yes, sir.
You put it in the mail. All right. Then I'm going to go ahead with the case. This is the motion by Mr. Holt, father of a 7-year-old, who's asking for parenting time. Says you say, first of all, the mother moved out of state, but then you're also telling me that she lives in Saginaw, which last I checked, we're still part of Michigan.
She was staying in Saginaw, but like my father, he's told me that she moved. It is. And that's what he told me. I guess.
How does he know?
Well, I guess to talk to her, he told me that she was asking for some money or something.
It's also in the motion. You say you had your child last April to August,
yes,
but then you also state in here you haven't seen your child for a year. You said in here, well, if you had the child as of last August, you clearly have seen her within the last year. And I understand there is no parenting time order. and you're requesting a specific parent. There was a judgment of support on December 8 of 2017, where mom got physical custody of the 7-year-old child. You say you've seen her in the past, but haven't seen her for a while. Is that correct?
Yes, sir. It's like, I hear from her and then like I don't know. She asked, okay, like after that, it's like I don't hear from her or don't see her or anything. It's like I only see her unless she really needs me, to keep her. And I just want to establish parenting time so that won't happen.
And you've seen her for large chunks of times in the past?
When she was like an infant, we were doing like weekly things. I keep her 1 week, and she'll have her the other week.
And then you said last year you saw her, she lived with you for 3 months?
Yes.
From where mom was apparently living here or what?
She was living inside my.
But did you enroll her in school here?
No, that was one.
Okay, she was living in Saginaw and you had from April to August. You would have had April, May, she would have been in school. Where was she going to school?
I believe she's going to Saturday, but when because her mother, she told me that we gotta come get her.
So what do you, here's a practical problem. I mean, I can order you to have some parenting time, but if you don't even know where she is, how you gonna enforce that?
Like my father, he told me he knows, and like I can have like my friends and like try to reach, to her on Facebook, find her location, and specific city she's in.
It's gonna be really tough if she moved to Louisiana. There's no order in here about legal custody. Okay, legal custody is whether she can leave and that kind of stuff. And there's none one way or another. We can start this whole process because you're asking for some specific parenting time, even if she's in Saginaw, okay, or around there. There's no reason that you can't see your daughter every other Saturday from 9 in the morning till Sunday at 6 o'clock. Okay. And you guys can split transportation. You can pick her up and she can pick her up from you. All right. And I'm just starting out with something here. Saturday, probably 10 o'clock to just giving you enough time to get over there in the morning on a Saturday morning. I assume you can do a Saturday morning.
Yes.
And to Sunday at 6 o'clock. Okay. We'll start out with that order starting next Saturday. All right. You pick up, she picks up from you. All right. Unless you two can agree on a center point, I don't care, but the order is going to say that you'll be responsible to pick her up. Now, that's something to start with so that we'll have a court order and start working on getting her. I mean, if you can't find her, I don't know where you're going to drive to get her on a morning. Are you paying child support?
Yes.
Well, the friend of the court must have some kind of an address that they're sending it to.
I'm assuming it's Saturday.
But you may want to work with the friend of the court some, because if you can't get parenting time, at her last known address or whatever, if you can't get it, you might want to file a complaint with the friend of the court saying I went over there and didn't get my child according to the parenting time order. File a complaint and see if you can start this process, because they should have some knowledge of where she is. Otherwise, they're sending money to her as long as you're paying it. I mean, I don't know if you're behind or whatever, as long as even if you're paying some of it, they should have some way to get it. And then we're gonna have to work with it from there. This is just a practical problem more than anything else. I'll see. I mean, I hope you can start getting some time with her. Let's just start there now, because I'm assuming that you're probably not going to get her next Saturday. But you got to make an effort and file a complaint with the friend of the court if she doesn't follow through on it. Okay, if you can't get her. Then if you do start getting her, you can ask for additional time or whatever is appropriate. That's up to you. All right. But this is only the initial step to try and get somewhere. Right. I hope you can see your daughter. All right. Work with the friend of the court the best you can, and let's see how we can do it. We will send out the order to you. We have your address, and we'll send it out. We'll see what the friend of the court says her last known address is, and we'll send it out to her also. All right. All right. Good luck to you. Thank you. Thank you for your patience. We're just trying to make sure that in case she showed. Thank you. DC. It's the matter of Calderon versus Molina. We have the attorney, Miss Garnicia, present, who represents the plaintiff. That the plaintiff is the mother.
Yes, and she is present with me.
All right. And I'm only struggling some because it's kind of unusual. You're here asking to enter a default judgment of child custody for the child Alejandro, who is 16 years old, correct?
Yes.
And I have gone through this, and I mean, it does appear appropriate that I would enter that default judgment of custody. It does appear that you've made all the efforts appropriate to serve the defendant. I mean, the defendant apparently lives where, in Honduras or something?
Yes.
And you've done your best to serve him, and he simply has not responded. I think it's appropriate that the court enter the default judgment of custody that you have, that you are seeking. Okay.
Okay.
And I know your other part is to make findings regarding Alejandro, make special immigrant juvenile status findings. Is that also correct?
Yes.
And I've looked through an extensive brief. I also had some other stuff that I looked through, which, because I was concerned that since this was the mother getting custody of Alejandro, that I couldn't make those special findings because she is the mother and everything. But after going through it, it's my understanding that the law does allow me to make special immigrant findings for somebody who is the other parent is found to be abusive and neglectful, and we are providing custody to the mother who is not abusive and neglectful. Anything you want to say about that, counsel?
No, just, yeah, that's correct. It's either one or both parents. So in this case, it's just one parent. So his mother has had custody of him his whole life, and continues to do so here in Michigan. So he cannot be reunified with dad because of the neglect, and we don't know where dad is. He left his life when he was very, very young. And that it's, not in his best interest to return to Honduras, where he doesn't have any family there, wouldn't be safe, would have to work and not be able to be in school.
All right. Then based upon that, I think I have to go through a number of things. The court does have jurisdiction over this young man through the custody order that I have just said we will enter. And so I am in a position to make findings. I have been provided a brief, but more importantly, I've also had a affidavit from the young man that I assume was appropriately signed by him, that I guess I would make the findings that this court does have the jurisdiction to make these findings pursuant to law, that Alejandro's reunification with his father is not viable at this time due to the neglect or abandonment of Alejandro. He apparently, the father left the home when Alejandro was 5 and has completely abandoned him since then. I don't think Alejandro has heard from him since that time, nor has the father even tried to contact him. When Alejandro did live with the father never really cared for him, never engaged with him. And to say it bluntly, he was clearly neglectful. It has been over 11 years since Alejandro has even seen his dad, I think, and he has never heard from him in the past 11 years. Alejandro did drop out of school at the age of 12. I assume that was back when he was in Honduras. Had to work extensively from 5 a.m. to 5 p.m. every day. He worked with sunlight, using a machete in his hands to, I think it was pick coffee beans. And was forced to fend for himself. As a result, I do find that it is appropriate that return to the father is not viable due to his abuse and neglect. It is also not in Alejandro's best interest to return to Honduras, mostly because he'd have to be returned to his father. I don't know what others are living there, but there is a statement clearly that in Honduras, the gangs are very prevalent, at least in Alejandro's area. They have killed members of his family in the past, and he is afraid of them because he is afraid that if he doesn't do what they require, they will either kill him or other family members. He will continue to be targeted by these gangs, and is not able to even achieve any kind of education because of that. The family left Honduras and struggled badly. The family he left in Honduras still is struggling because of that, the gangs that are down there, and return of Alejandro to Honduras would not be in his best interest by any means. So I guess I would make that finding also. Counsel, obviously you can tell because I'm not exactly zipping through this, that this is an unusual thing that I'm doing, but I think I've covered the bases. Is that your understanding? Do you need me to make any other findings at this time?
It would just be that he's, because two other things is that he's unmarried and he's under the age of 21. He is 16 years old and not married.
All right, he's 16 years old, and lucky for him, he's not married.
Yes.
At that age, it's a little bit too young.
Yeah. Yes.
Anything else that you need from me?
Nope. So granting custody and the special findings.
I think I did both of those.
Okay. Yep. That's all I need, Your Honor. Thank you so much.
All right. I think I've got appropriate orders to sign here. If I have some difficulty or whatever, I'll have my clerk contact you so we make sure I sign the correct orders. All right.
Yes, that's perfect. Thank you.
All right. Thank you very much. I appreciate your help. Thank you. Good
Bye.
luck. Bye. Miss Van Dyken to see if she's showing up.
I
Okay.
don't think she's coming to this one.
Do you know why?
I just don't think she coped with her schedule.
Have you talked to her about this matter?
Yeah,
And it's all right that she's not here?
yeah.
Ms. Brower, do you think that's sufficient to allow us to proceed?
You know what? I guess so, Your Honor. I haven't heard from her directly as to whether or not she would be attending the hearing or not. I guess if Colleen says that she's been given permission to attend this hearing without her attorney being present, I would assume it's okay.
We're gonna email Miss Van Dyken just to make sure.
That sounds good.
I mean, quite frankly, I'm not even sure why we're necessary on this one, because there's a child support order for dad already, and there's a stipulated order of affiliation.
Yeah, because I still need to apparently get a judgment of paternity entered so that I can close the case. That's why there's nothing has been entered regarding custody or parenting time. And then the language needs to be included that this order resolves the last pending claim and closes the case. So that's why.
Well, but I mean, quite frankly, your paternity orders basically give mother physical, but really it doesn't mean anything, because I think most of them just say, but it's without prejudice to either party seeking it. If I'm not incorrect, doesn't really resolve. Have physical custody of the minor child. All right, we'll contact Ms. Van Dyke and see if she has any objection to that order. Because as I say, you don't need a child support order because there's already one in place. And he does have legal rights because he is determined to be the father through the order of affiliation.
Correct. Yes, but I still, it's my understanding. I still need to get a judgment of paternity entered for me to close the case at this office. So.
All right. All right, well, we'll contact her, Miss Holleran. You can mute for a second. We'll see if we can contact Miss Van Dyken, and we'll take another case of yours.
Mm-hmm.
All right. Miss McCutcheon, can you hear me?
Yes.
All right, we're here, McCutcheon versus Robinson. We have Miss McCutcheon present and the prosecutor, Tracy Brower, but we do not have the defendant. He is not logged on to the best of our knowledge. He's not here in the courtroom. has never logged on. I believe he has appropriate notice of this. This is an order seeking, a judgment of support in this matter. They're listed as 0 overnights. I'm not really sure what it says about a prior child. No, nothing was given as far as an additional child adjustment in this, but it sounds like he has another child who spends like 4 nights a week or maybe you can clear this up, Miss Brower, because the plaintiff says the dad works 2 jobs. I think you've imputed him at $17 an hour times 35 hours. Maybe you can clear this up for me.
Yes, to my knowledge, he's not working at all. The last that I knew. So we were last in your courtroom on Zoom on January 23rd, 2024. I take that back. There was a pre-hearing conference on January 23rd, 2024. The plaintiff only participated. I called the defendant twice for that pre-hearing conference and he did not answer. The plaintiff earns $25 an hour at 40 hours per week. In addition to that, no, that's right. She earns $25 an hour at 40 hours per week. The defendant, I imputed him to $17 an hour at 40 hours per week. He last worked at Pridgeon and Clay, earning $20 an hour. So after the pre-hearing conference, at that time, mom told me that the minor child spends 4 to 5 overnights per week with dad. So I ran a guideline giving him 4.5 overnights per week. And when I did that, the recommendation was actually for mom to pay. And that's how that original paperwork was drafted. Because it was recommending that mom pay and mom receives public assistance, I asked the court to simply reserve child support. However, prior to that court hearing on February the 23rd, mom called me roughly around February the 14th and stated that the minor child is no longer spending overnights with dad. And on the record at the court hearing on February 23rd, she stated that the reason for that was because she switched from 3rd shift to 1st shift. So what I tried to do at the time was to, instead of asking for support to be reserved, to ask the court to order $474 per month for the defendant to pay in child support, given that there were no longer any overnights. However, the court wanted me to renotice it so that the defendant would know that instead of me asking for child support to be reserved, I was now asking him to pay $474 a month in support. So I hope that kind of answers your question, Your Honor.
All right. Ms. McCutcheon, does Mr. Robinson exercise any overnights with the child?
No.
None, and has not for the past couple months?
Yeah, since I went back to 1st shift.
All right. Well, then with that in mind, and I think you have imputed him at $17 an hour times, you say 40 hours a week? I thought it was 35, but
Let me see. Hold on a
it
second.
seems like it might be giving him a break because he was earning $20 an hour.
Yeah, I did 17 an hour times 40 hours a week. That's
Right.
what I used. Mm-hmm.
All right, since we're trying to do the best we can, considering he's not working or whatever, ma'am, you say you think he works 2 jobs?
Yeah, he does.
Where does he work?
He has a full-time job. I don't know exactly what it's called. It's some on Chicago Drive working with fire trucks. He works there full-time Monday through Friday, and then he works at the Drunken Monkey on the weekends, like 6 hours a day, some weekends.
If you can get us some information as to where he works. Unfortunately, the prosecutor doesn't know how much, you don't have any idea how much he makes at his job, do you?
Me?
Yeah.
No, I don't know how much he makes. I don't even know how to figure that out.
All right. No, I didn't know I don't know if you have any contact with him, because for a while he was watching your child 4 nights a week, and
Yeah.
no, there isn't anything. So I guess in an attempt to get child support going, I'll enter the judgment that the prosecutor has presented, which has him paying some $400 and some a month. If you come up with something that you think we should recalculate, contact a friend of the court and we'll recalculate support if we can get some information about him working and stuff like that. I just want to get child support going. All right. I don't want to put it off anymore. So I'll enter the order that's here. It'll be effective 2/15/24. And, let's see how we proceed from there. All right. Do you have any objection to that, ma'am?
I do feel like it should be based off what his last income was and not just a low income, especially since he's at least able to make $20 an hour
Yeah,
based off his records.
All right.
yeah, Your Honor, at the time, what it was, when I used the 17 an hour, I knew that the minor child was spending half the overnights,
All right.
pretty much with each of the parents. So when I ran it using with the child spending 4.5 overnights with dad a week, it made no difference whether I used 17 an hour times 40 hours or $20 an hour times 40 hours. It made no significant difference. And so when I ran it, I just kept dad's income as the same. As the court has indicated, yeah. And I have no
appropriate to do $20 an hour because that's what he was earning at Bridget and Clay, I think you said.
Yeah, he was earning 20 an hour. Correct. Yep.
It appears that he's probably working and maybe even working more than that if we include the drunken monkey, but we don't have any information. So you can recalculate it at 0 overnights at $20 an hour times 40 hours and submit that through to me. That'll increase it, ma'am. I have no idea how much, but that'll at least make him responsible for what he was earning in the past. And
I appreciate it.
And again, if you get more information and think it's appropriate, talk to the friend of the court and see if they can recalculate it. If you get more, like you find out, he's working at $25 an hour and working 6 hours a week at, whatever. I just want, they're just numbers. I just want them to be correct. But well, let's start out at $20 an hour times 40 hours. If you will submit that to me, I will sign it.
I will, Your Honor. Thank you.
Thank you. Thank you, Ms. McCutcheon. Appreciate
Thank
it. Thank you. We're adjourned. Okay, Stacy says she's not coming, so let's just do this particular case.
Okay.
All right. Mahone versus Halloran. Prosecutor Tracy Brower is present. The defendant, Ms. Halloran, is present. There was an attorney listed on this, Stacy Van Dyken, but she is not going to appear, and that is fine with the defendant. The plaintiff, Mr. Mahone, has not appeared, even though he was noticed. As I stated before, there is a UCSO in place from 11/3/23, so we don't need to do that. It's my understanding, and maybe this is not quite correct. It sounds pretty correct, that the prosecutor really needs a form of a judgment of paternity entered so that they can close the case out. There is an order right now of affiliation, so the father is deemed to be the legal father. But under the circumstances, in order to close this case out, they want me to sign the paternity order, and I think that's appropriate at this point. Ms. Holland, do you have any problem with me signing the order that they have?
No,
submitted?
that's fine.
All right, Ms. Brower, you can submit that order to me, and I'll sign that one also, okay?
Okay. Thank you so much, Your Honor.
Wait, all right. Anything else you wanted to say?
Nothing for this case, Your Honor.
All right. All right. Thank you, Ms. Halloran, for your patience. I do agree. I do appreciate it. Thank you. We'll sign that. And neither party is present. Ms. Brower from the prosecutor's office is present. This is regarding a child named Clarence. There's a request from Ms. Brower to enter a judgment of support. It appears neither party has appeared. It's 10:30 and they were noticed for 8:30. That the person that you are seeking a child support order from, if you will, that being the defendant, is on SSI, so we can't collect child support from him anyhow. You're just asking that a child support be entered at 0 at this time and see what happens in the future. Is that correct?
That is correct, Your Honor.
Unless you have anything to add, I will sign that order when you send it to me. I think it's appropriate. All right.
Nothing further from me, Your Honor. Thank you so much.
All right. Thank you. Is that it for you, or you still got more?
I have one more. Ugalde versus Mitchell.
Goodness. Ugalde versus Mitchell. We have present Ms. Brower, who's noticed this out for hearing on this day. It was noticed for 8:30. It's now 10:30. Neither party has shown up. This is a request from Ms. Brower from the prosecutor's office for child support. I think it's for 2 kids.
That's correct.
There are 0 overnights, at least as far as she is able to determine at this time. Mother was given potential income. Apparently she works 20 hours a week at $18.85, and you've imputed her an additional 15 hours at $11 an hour. Dad has not apparently shown for anything. And you have imputed him. Ms. Brower, can you still hear me?
Yes, I can hear you.
We just had an interruption there where everything went blank.
Yeah, that was strange.
The only thing that I questioned in what you said was why you imputed father income. You did not say what you imputed it as.
It may have been an oversight on my part, Your Honor, but let me read to you what I did. So the father, let me see. I imputed him to $15 an hour at 35 hours per week. He was released from prison on December 28th, 2023. After he was released, he worked at Forge. He worked through Forge at a place called DPB Environment, where he earned $15 an hour. He also earned $16 an hour working under the table doing construction for a friend. And he also did DoorDash, and he stated that he earned $70 to $100 per day. So that's what I imputed him to, $15 an hour at 35 hours per week. I thought that I had put it in the guideline, but maybe I just forgot.
I think you forgot, because I did go through the potential factors, including the fact that he has worked at DPV Environment, was doing work under the table, and DoorDash. Education was unknown, doesn't appear to have any physical limitations. Although he stated he did receive SSI at one point around 2015, but he's not receiving it now. He does appear to be available for work. The unemployment rate in Kent County is extremely low. He has been able to find work, as you have stated, in the three, DoorDash, under the table, and DPV. One negative is that he has spent time in prison, I think, recently, being released at the first of the year. He is single with no verified disabilities. And as I say, I went through all of it, and it says his assignment at Forge earned him $15 an hour, ended a week ago. So there was nothing in here, but you're telling me you imputed him at $15 an hour times 35 hours. Is that correct?
Yeah, I sure did, Your Honor. I apologize for leaving that out. Just an oversight on my part.
That's all right, I believe. And he, to the best of your knowledge, he has 0 overnights. Did you talk to anybody in this case?
I did, Your Honor. So there was a pre-hearing conference on March 12th. Both of the parties participated.
All right. And he does not have any overnights?
He does not.
All right. Well, imputing him at the lowest amount that he's been making lately, I think, is appropriate. It, for him, ends up with, I think, mostly because of childcare, his expenses are extremely high, of $209 for the 2 kids. Do you have, has that been verified appropriately through the mother?
Yes, Your Honor.
All right, then I'll enter the order that basically calls for 2 kids at $824 a month at this point. I will sign that order that you provide to me whenever you do so.
Okay, I'll send it to you today via DocuSign.
All right, thank you very much. Anything else?
Nothing further from me.
Have a great weekend.
Thank you. You do the same.
Thank you, Springer. Both parties are present via Zoom, as well as Ms. Sierra on behalf of Ms. Springer and Mr. Steffen on behalf of Mr. Springer. This is unusual in that it's a motion to enter a default judgment of divorce. I'm wondering why that wasn't done on a pro-con day.
I can't explain that, Your Honor. But what I do know is we scheduled it for today. I'm happy to reschedule it for a pro-con day if that's what you would prefer. I believe probably the thought behind that was making sure it got in front of Judge Hillary or yourself, and not one of the other referees, to ensure the equity of the default judgment.
Well, let me ask Mr. Steffen a little bit here. Mr. Steffen, you understand this is here for a default judgment. I did look through the file. I mean, I know you filed a motion to set aside the default. The judge said no, denied your request. It's here. Are you objecting to the entry of this default judgment? And if so, why?
Your Honor, we actually are in agreement with a good portion of the default judgment. However, as Judge Hillary did state when he denied our motion to set aside the default, there would still be an opportunity for an equity hearing to determine that the judgment itself was fair and equitable. There are only two provisions of the judgment that we do object to on the equity basis. The first is the 90 days to pay out the funds. And that is because my client has already spoken with Chase Bank, and they've told him it will take more than 90 days to process the refinancing. He's gotten it
How many
going.
days does it say?
I'm sorry, what was that?
How many days do they say it's going to take?
How long did Chase tell you it would take?
I would have to get back with him today.
He's got a meeting with them later today. I do know that. I don't know that they gave him a specific time, just that it would not be within 90. I don't think we would be looking at going more than 120 or 150 days on that.
I wouldn't grant them. I mean, 90 days seems like enough to refinance anyhow. How come? Why the holdup?
Your Honor, again, it's not on my client's end. He's already gone to Chase before this has been entered to talk to them about getting the refinance going. So I don't know what their reasoning is for what the holdup would be.
Well, I can tell you if it's the result of Miss Springer and she comes in to get collection after 90 days and she's the one at fault for holding things up, she's not going to get enforcement of it. All right. But I need your client to make all due diligence starting today to do that. I think this is 90 days, as we all know, is plenty of time to refinance unless Miss Springer is failing to provide a, quit claim deed or whatever, in which case her claim for that is going to fall on deaf ears.
And that may have been what Chase was implying when my client spoke with them previously. Again, he's already got everything in place. He's got a meeting with them this afternoon for that. And I will, of course, relay to Miss Sierra or Miss Slight or whoever maintains primary control of this case status on where we are with the refinance.
All right. What's your other objection?
The other objection is to the alimony portion, and that is specifically because during the course of the marriage, Miss Springer did work. She did earn cash under the table and is actually currently earning more than my client is. She sent a text message to the party's daughter in January saying she had just taken a job earning $30 an hour. It does seem inequitable to have the spouse who is earning less paying spousal support to the spouse who is earning more.
You're in a real tough situation, Miss Sierra, because I don't know that you've been working on this case. I did look through everything that appears to be equitable, all of the division of the property. However, I guess they have the right to object to the equitable nature of the spousal support, and that would have to go in front of Judge Hillary. What are your thoughts, Miss Sierra?
Well, I have several thoughts, Your Honor. I think the reality is when we're looking at spousal support, there are several factors, and I understand that if there's a dispute in this, that it's going to have to go in front of Judge Hillary. But the reality here is when we look at the entire situation and we look at the factors of spousal support, what we proposed in this default judgment and the USSO that was provided is probably less than what it actually should be. When we look at really everything that has happened in this case. I don't think that it should go unnoticed that this case was filed on April 17th, and we have had nothing but difficulties trying to gather the information in order to provide the court with an equitable default judgment. We were not provided statements. We were not provided anything like that. So there has been significant delay on this because of just a refusal to provide information. And so it's really put my client in a very difficult situation in that we were trying to put together an equitable judgment, but we weren't getting any information in. So the reality of the situation is if this is going to continue to move forward, my client's going to need attorney fees even beyond what we've been asking, because she continues to incur costs just because Mr. Springer doesn't want to participate at all. I mean, even to give us information. So it's kind of one of those situations where, okay, I understand where we are, but it's going to come out in the other end. I find it very difficult to understand why with the equity payment, if 90 days isn't correct, I mean, if 90 days isn't appropriate, they need more than that. This goes to the entire theme of this case. Mr. Springer has delayed everything to push everything further out, and then what he's doing is he's pointing to those delays as a reason why he can't move forward, which has just cost our client an astronomical amount of attorney fees. I mean,
Well,
if
I'm
you-
gonna
house
tell
you
right
should
now,
start it.
even if I don't enter this, I'm gonna tell Mr. Steffen that, and I send it up to Judge Hillary, I'm gonna tell him right now that refinance better be done 90 days from now, no matter what. I'm not gonna enter a judgment. I'm gonna suggest that he doesn't give him another 90 days at the time of entering this judgment, because he might have to have a short hearing about spousal support. And if he does, I'm gonna tell him that he's been notified now that he's got 90 days to get it done. And unless Miss Springer is a problem with it, unless she doesn't provide what it is, he's not going to come in and say, gee, I don't have the judgment yet and I don't know what I'm going to do. You're going to have to refinance that within 90 days of today's date. I don't care what it is. You understand what I'm saying, Mr. Steffen?
I do. And Your Honor, it was more just to, again, notify the court that he had been told there could be a potential issue with that. He's going to do everything in his power to get it done, and again, is already active on that. The fact he's already talked to Chase is more than most people would have done in this situation.
Well, it may be, but it also, I mean, I've had many who talk to him and then they just sit around and wait for this and that. I'm just telling him right now, as plainly as I can on the record, that he's not going to get more than 90 days to refinance that house from today's date, and that should stay in the default judgment, whatever that date is. He's not going to get more than I can't make a statement for Judge Hillary, but I'm going to be very strong in stating it here so that they can get a copy of this opinion and take it up to the judge, but I'm going to go up and tell him anyhow. My only problem with this, Ms. Springer, is the only area that I don't know whether I've seen the calculations. They appear to be correct, but I don't know if they are on spousal support. And I don't know what her job is and what it isn't. I do know the number of years of marriage and stuff like that. I do know that the score and everything, the prognosticator, if you will, for alimony seems to indicate the amount of money that you've asked for the amount of time. And be aware, Mr. Springer, that if you want it to go in front of Judge Hillary, that's fine. I'll send it up for that. But be aware that if he finds that much or more as appropriate in spousal support, again, I'm going to recommend to him that cost for all that hearing and everything is going to be yours also. All right. So we'll send it up for Judge Hillary. If you want, I can take proofs right now and preserve them. But I'm telling you now that if you go up there and you're disputing this and you lose this, I'm going to highly suggest to Judge Hillary that you pay every penny of Miss Sierra's cost for that hearing. You understand that?
Yes.
All right. Miss Sierra? My biggest problem is entering a disputed spousal support. At this time, he does have limited to no ability to, get discovery and all that kind of stuff. He has very limited because of his default. But because he is challenging that on an equitable basis, and I really don't know everything about spousal support, I will send it up to Judge Hillary on the issue of spousal support. Is there anything else you're challenging, Mr. Steffen? I didn't.
No, Your Honor. Again, while there are parts my client doesn't love, he understands that he was in default and that 50% of the equity in the house, 50% of the equity, that all appeared to be fair and equitable. It was truly the alimony was the only part that did not appear equitable, and the refinance was more of a advisory. We're doing what we can. We just want to give you a heads up.
All right, Ms. Sierra, I've been really straightforward on what is expected of him. I will take this up to Judge Hillary for him to set up a spousal support as quick as possible. You can will reserve your request for attorney's fees. That's something that I would have had to have a hearing on anyhow if you were asking for them.
Right.
It's not part of this. I'm going to take it up there. I'm going to suggest that they set up a hearing regarding spousal support promptly. And I'm going to tell him that if it comes out at this amount or more that he's supposed to pay, that Mr. Springer is going to be held responsible for the total costs of this hearing. So basically from now on, pretty much. All right.
Thank you, Your Honor. I can put that, I will put that in an order. I would request if the court would allow us to put proofs on. It is my most sincerest hope that we will be able to resolve this without a spousal support hearing. In the event of
Mr.
that,
Stephens, do you have any problems with her just me preserving proofs?
Your Honor, that makes the most sense to me. And frankly, Miss Sierra and I have always had a very good working relationship.
I know you do.
If she and I can talk this out, we might sort it without.
If the two of you can't figure it out, it can't be figured out. I think both of you are both very reasonable. We turned the recording off while I said that, though. So, with that in mind, you can stay for just a minute. Ms. Springer, would you please raise your right hand? Do you solemnly swear affirm testimony given in this case to be the truth, whole truth, and nothing but the truth?
I do.
Thank you very much. You may put your hand down. Ms. Sierra is going to ask you some questions so that I can preserve proofs for the final matter of getting you guys divorced. Ms. Sierra.
Thank you, Your Honor. Ms. Springer, were the allegations contained in the complaint true and correct when you signed the complaint for divorce?
Yes.
And are the allegations contained in the complaint for divorce true and correct today?
Yes.
Are you pregnant?
No.
Did you live in the state of Michigan for 180 days prior to filing the complaint for divorce and the county of Kent 10 days prior to filing the complaint for divorce?
Yes.
Has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there is no reasonable likelihood of reconciliation?
No.
But, okay, I'm going to say it, okay.
That again.
It's a lot.
Yeah.
Can you reconcile, ma'am? Are you guys back together?
Are we? No, we're not back together.
No, you don't plan on it?
No.
This marriage is
never
done.
Done.
Go ahead, Ms. Sierra.
Thank you, Your Honor. I'm sorry about that. And you have read and understood the terms of the default judgment that we have presented, correct?
Yes.
And once we have either an agreement on the spousal support and we have a full judgment, are you in agreement to have those terms be entered and you'll abide by them?
Yes.
Thank you. I have no further questions, Your Honor.
Mr. Stephens, is there anything you wish to say or ask or whatever?
No, Your Honor.
All right. I'll preserve proofs. Hopefully the two of you can work this matter out sooner rather than later, although I will say that I will take this up to Judge Hillary, if I remember, as soon as I'm done here, for his office to contact both of you and set up a spousal support hearing as soon as possible to get this done. Again, work on that refinance, because there's not going to be any reason to go beyond that unless Miss Springer is the one who is at fault. All right. And
thank you.
Also, in the order, you can preserve attorney's fees. I'm not going to make any ruling on it at this point.
Very good. Thank you, Your Honor.
Other than the fact that if the spousal support goes against Mr. Springer, that he is to pay for the full hearing.
Very good. I will include that.
Thank you, everyone. Have a good afternoon. Take care.
Thank you, Your Honor.
Coriano versus Garcia. Both parties are present via Zoom. This is the request from the mother regarding child support. She wants to reduce father's child support, which is currently set, I'm not sure, I gotta look it up, but $652 apparently a month. She wants the child support to go to zero, is my understanding.
Yeah.
And she wants to forgive arrears. Let me start out, ma'am, with your request for forgive arrears. I'm not going to order that. I don't know if any of it is possibly owed to the state or whatever. You can work with a friend of the court to forgive arrears if you wish to do that, but I'm not going to order it at this point.
Okay, so I have to go through like front of the court?
Yep, I don't, because I have no idea if some of it is owed to the state or whatever. All right, so,
okay.
And you certainly can't forgive arrears that are owed to the state. You can talk to the friend of the court and work on that, but I'm going to deny that portion of this. As far as you also want to make child support zero, why is that?
Because so basically when I was getting help from the state to get like I think it was like food assistance, or I even applied for something else at the time, but basically they contacted me and told me because my daughter's getting Medicaid through the state that they need to like, I need to comply with child support in order for her to continuously get Medicaid through the state and stuff. And so basically they put like a non-compliant in order for me to, you know, get assistance with that, like Medicaid. And so I was communicating with him and let him know all that. And so we went the route of doing the Medicaid, doing the child support until we were able to get Caroline onto his insurance, which we ended up doing. So now she's on his insurance, and they told me, like, we went through mediation, we went through like a different couple, like,
And you didn't agree at mediation.
oh no, because mediation, it wasn't like a disagreement on mediation. The guy ended up telling us that he doesn't necessarily deal with child support per se. He more deals with like, you know, the arrangements, like food. I'm sorry.
All I'm saying is, this is support for your child. Why should I make it zero?
Because he already helps. You know, he helps when it comes to parenting time. Like we split. She stays with me the school year. She goes with him during the summer, and then on certain breaks. Then also he helps with like clothing, and if I ever need help with like anything when it comes to school snacks, if I want to take her to go do something, he has no problem. All I have to do is ask him. He never gives me an issue with that.
Is there any state assistance involved, whether it's food stamps or anything? I mean, is there?
Yeah, I get food stamps, but I already spoke to like FOC and the food stamps people like DHS, and they let me know that that food stamps doesn't require me to have to put him on child support, only if if I'm getting Medicaid for my daughter.
That's bad information. If the state is paying for any funds for your daughter, all right, then he has to be on child support, because otherwise the state pays for it. The people of the state of Michigan are paying for your food stamps for your daughter when we have somebody who should be reimbursing the state.
Okay, well, I have no problem like removing the food stamps.
Well, when you do that, you can, if and when you do that, you can always opt out of the friend of the court if you want, and just not have them involved. And even if the order's out there and he pays you, you can pay it back to him. But I cannot, I can't order zero when there is still state assistance being paid. So sorry, but that's just something, and I'm going to have to deny that. You can work into the court to get rid of the arrears if you really want, but I don't know if it's owed to the state, you won't be able to, and I'm not going to be able to stop child support as long as there is state assistance still being involved, because.
Okay, so can we at least reduce it if he's already helping me with other things?
Not at this point. Look, if he pays you the money, he's not going to have to pay you money for other help. You can pay it back to him. I mean, I don't know what happens when it gets to your door, you know, but he has to pay it, and you guys can figure it out from there, because I don't know how much is owed to the state, and I can't just pick a number out of the air and say, okay, we'll reduce it so that I know that the state is being reimbursed. It's just the way it is. As long as the state is assisting you, then the father has to pay back the state. So I'm going to have to deny your request at this point. Thank you very much. We'll issue an order for it. Thank you. Talk to the friend of the court. Work with the friend of the court. Thank you. We have a star here. How you doing? Thank you. Thanks for. Do you know Annie and Tatiana? Yeah. You'll never remember his name, but you'll remember Ghost.
I know, we'll remember. Okay, we just have one more.
One more motion?
Yes.
Oh,
she's the only one in the greener.
All right. Bring her in. Most fun you'll have today when you watch that dog, I think. Ms. Bennett, can you hear me?
It's still connected.
Ms. Bennett, can you hear me?
Yeah, sorry, I don't know why it wasn't.
That's all right. That's all right. This is Kate Bennett. Only one party is here. I assume you notified Mr. Bennett of this.
Yeah, he's actually incarcerated, so I sent the letter straight to jail.
Is he in the Kent County Jail?
Yes.
All right. Well, this is your request due to a recent birth, I think in the last couple weeks, of a child that you say is not his, and that but you do have a DM divorce here. We will order a genetic testing, DNA testing for you and the child and Mr. Bennett. We should be able to get it through the Kent County Jail. Even they should be able to do that. We'll issue an order that everybody has to abide by genetic testing. Once that's done, we'll deal with it at that point. Okay.
Yeah, and then after that's done, we can like move forward with the divorce, right?
Hopefully, yeah. You still got 3 other kids, I think, during the marriage.
Well, that's okay. So last time I spoke to you, that's another thing. I don't know if this is possible or not, but my 3 other children are not in my care and have not been in my care. They're actually signed off to my mother.
Well,
But-
they're children born of the marriage, and he's still the father.
Okay, so I thought he signed off on them also. So I didn't know if that made it.
Signed off, I mean, maybe guardianship, I don't know, but I'm only here to ask about this one thing, and that's a ROPA motion regarding Jalia? Jalia, and I will issue an order, so we'll get genetic testing and at least figure out Jalia as soon as we can, all right?
Okay.
Thank you very much. We'll get that out to you and out to the jail so that he can be tested.
All right, thank you. It'll come here in the mail.
Pardon?
Letter or something will come in the mail, or do I gotta come back
You'll
down?
get the order, you'll get the order in the mail.
All right, thank you.
Thank you. And that's the end? Hallelujah. We should show it up earlier.